right, everyone. This is Zhang 안녕하세요. Please, welcome, ladies and gentlemen. Good evening. Please sit down. So, for the first plaintiff, are you ready?
Okay, I'm a senior lawyer acting for the plaintiff. First, the plaintiff elect that the extraordinary general meeting by the 5th defendant through the 6th defendant in the 1st, 2nd, 3rd, and 4th defendants is invalid and no legal effect. It was maintained by the plaintiff that as a corporate representative appointed under S 147 of the Companies Act 1965. The 6th defendant was not empowered to convene any EGM. Second, the plaintiff declared that the board meeting of the 1st, 2nd, 3rd, and 4th defendants convened on August 5th, 2019 are invalid and effective. It was contended by the first plaintiff that his availability to attend this board meeting or to have been essential certain before they were convened. On the fact, the board meeting were convened for August 5th, 2019, without it being first determined whether the first plaintiff could attend it. On July 31st, 2019, the director were informed that among them had convened a meeting of the board scheduled for August 5th, 2019. The plaintiff third, the plaintiff declared that resolutions passed at the board meeting of the first defendant on August 5th, 2019 are invalid, ineffective, and null and void. Article 33 of the Articles of Association of the first defendant provides that 21-day notice by giving when a special resolution is proposed to be passed. The requisition for an EGM of the subdirector specified that the proposed resolutions that the EGM were to be a special resolution.
I'm the junior counsel acting on behalf of the plaintiffs. The fourth issue. The plaintiffs declare that the EGM of the first defendant convened by the board of directors of the first defendant on 5th August 2019 are invalid and ineffective. It was contended by the plaintiffs that once Section 311 of the Companies Act 2016 is invoked to convene an EGM, the provisions under Section 310 of that act may not be invoked to convene an EGM. The fifth issue. The plaintiffs declare that the EGM of the 2nd, 3rd, and 4th defendants convened by the 6th defendant as corporate representative for the 5th defendants on 22nd August 2019 is invalid and ineffective. It was contended by the plaintiffs that once Section 311 of the Companies Act 2016 is invoked to convene an EGM, the provisions under Section 310 of that act may not be invoked to convene an EGM. The sixth issue, the plaintiffs declare that the resolutions passed at the EGM of the first defendant on 8th August 2019 are invalid, ineffective, and null and void. Besides, the plaintiffs also declare that the resolutions passed at the respective EGM of the second, third, and fourth defendants on 26 August 2019 are invalid, ineffective, null, and void. It was contended that pursuant to Section 206, parentheses 3 of the Companies Act 2016, special notice is required of a resolution to remove a director. For the purpose of the Companies Act 2016, where special notice is required, at least 28 days notice of the intention to move the proposed resolution must be given. In respect of the second, third, and fourth defendants, notice of their EGM scheduled for 26 August 2019, convened by the fifth defendant as their shareholder to remove the plaintiffs as directors was given on 22nd August 2019. The notice given were no more than 4 days. No special notice was given. No special notice was also given in respect of the resolutions to be passed at the first defendant's EGM of 8th August 2019. Therefore, if Section 203, parentheses 3 of the Companies Act 2016 applies, pursuant to Section 322, parentheses 1 of the Companies Act 2016, the resolutions passed at the EGM of the first defendant held on 8th August 2019 and at the EGM of the second, third, and fourth defendants held on 26 August 2016 would be effective, would not be effective. That's all. Judge, thank you.
Okay, thank you. We got it. So for the next defendant, you may start now.
Okay, thank you for Judge. I am Cecilia Constance acting on behalf of the defendant. Defendant claims that the convenes of the EGMs by the fifth defendant was pursuant to Article 15.8 of the Article of Associations of the second defendant and pursuant to Article 15.9.2 of the Article of Association of the third and the fourth defendants in the Section 310 of the Company Act 2016. In this regard, the terms used in the fifth defendant's Board of Directors resolutions of 16 July 2019 corporations representatives had merely the effect of identify the sixth defendant to effectuate its resolutions. For completeness, Section 333.1 of the correct Companies Act 2016 provide that corporations which is members of a company may authorize persons or persons to act as its representative or representatives at the company's meetings. It's also under Section 333.5 that a certificate of authorization by the corporations shall be prima facie evidence of representatives' appointment or the revocations of his appointment.
I'm the junior counsel acting on behalf of the defendant. Having regard to the foregoing and contrary to the plaintiff's contention, the requisition were, in my view, in compliance with Section 310 to 311 of the Companies Act 2016, as they were requisition of the fifth defendant as the sole shareholder of the subsidiaries made on this behalf by the sixth defendant, having been properly authorized by its board of directors to do so. Therefore, of the view that the requisition for an EGM to be handled by each of the subsidiaries made on 29 July 2019 were requisition made by the 15 defendants, and they were valid requisitions. It was contended that there was a misuse of the corporate power by the fifth defendant and also by the subsidiaries. That's all the defendant's part.
Okay, thank you. Based on section 147, third of the Companies Act 1965 says, a corporation may by resolution of its directors or other governing body, in addition, citing the recent case of Yang Binghong claims by Mount Oscar, the Hong Kong Court of Appeals, HKCAO 2413, the Hong Kong Court of Appeal considered the powers for the removal of directors provided under Section 462 to 463 of Hong Kong's Companies Ordinance, Cap 622. Although those provisions are closer to those of our Companies ACT 1965 than those of 206 of our Companies ACT 216. And the common sum is the same and is related to the shareholders' powers to remove directors. It needs reason since the statutory right to its removal is unqualified. There's no request for a reason for the removal or for the right to give an opinion. The second circular resolution signed by the majority was drafted the same day the error was found in the first. Moreover, as previously stated, the second resolution was only by letter of January 25, 2010, and no credible explanation. It cannot be accepted why the plaintiff in the same letter will be specifically noticed of effective January 1st, 2010. Therefore, I find, based on the assessment of the evidence, that is first defendant's description of the facts was inherently impossible. Directors affected by the notice resolution must receive full prior notice. Article 19, there's no exception to the factual requirements of this case, as a notice is true and effective. Besides, to send a circular for signature as a faith company and to attempt to achieve an unanimous decision to have a director retire as a finance director in that context cannot, in my view, be an act that should be allowed to pass as a valid decision. It also demonstrates that the exercise of improper legal purpose of a corporate power. So in conclusion, due to the above-mentioned reasons and laws, the statement sought by the plaintiff was not made, and the originating statements are rejected, and the defendants must bear the cost. Okay, that's all for today's court.